I'm a bad mood, gotta keep it tight. Hold my baby squid, keep him out of sight. Talking about my life, government, stay away. Watch me drive, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. Mama to my baby, protecting with my no government intrusion. I control my life.
Hey guys, it's Squid. Welcome back to the channel. How is everybody doing tonight? Oh my goodness, what a day. So I wasn't going to go live because I didn't want to read the other motion because I didn't feel it was necessary to go live for a one-page motion. However, that being said, the judge decided to drop his opinion and his ruling on whether that the new defendant shall be added. So we'll get into that. We'll also get into the why, the what we think will be going from here. And is this really a win? Because Jeremy seems to have backup plans for days. Like, this is plan A. He did mention that you just because this one might be denied, that even if it was, they would still be getting, something. And Unghung Hero, thanks for getting the day started off great with a $2 super chat. I can always count on you, my dude. So, how is everybody doing tonight? Can't stay long. Gotta studying for finals tonight. You go and you do whatever you need to do. Flash fan, you are my biggest cheerleader, my biggest supporter outside of those individuals in my own family. So you do what you need to do, and I promise you I will be here when you get back. I am not going to go anywhere. Hopefully. So joining me for this, because it's so much fun, Georgie. How are you, my friend? How are you?
I am wonderful. We weren't expecting this.
Not really. Your mic is a little low. I'm going to turn you up, okay?
Okay. That way I don't have to mess with the button.
Yeah, you don't mess with you. I'll mess with you.
Ooh, like it like that.
You and your you starting drama all the time.
It's not drama.
And thank you, Skipper, for the 99-cent super chat. So we're going to first read the motion from earlier in the day that most people heard about already. However, I didn't feel the need. I did put this motion in the Discord earlier today. However, I didn't feel it necessary to read a one-page motion by itself. But now, since we're going live to read a different motion, we might as well just discuss this one too. Get a 2-for-1 deal. And I know, Georgie, you probably discussed this one earlier on your live stream with Coop. But what did you think of it?
The approval?
Yes, I am going to. I just had to make it bigger.
We expected it.
Yeah. So this one about the mediation.
Right. Yeah, we expected the answers that we got from it. Because mediation wasn't going to go anywhere anyway.
Yeah. And my theory was if they were to add other defendants, this mediation would be moot because you'd have to do mediation between all parties and that would throw off the timeline. However,
it cost way more money.
Yes, and cost way more money. And it's one of those situations of, there was a comment on my thing today about when I woke up this morning about Bubbles filing motions and how it proves Bubbles filing motions proves that Jeremy is vexatious in his litigation. Make that one make sense to me, because if this is really a regular client lawyer relationship that Bubbles has with Lynette, every motion Bubbles files costs Lynette money. So, like, all the yeah. Oh yes, Flash fan, we are dual streaming. So if you are on my side of things, go over and drop Georgie a like and a follow. We are over 900. We are over 900 subscribers. She is well on her way to being fully monetized with 1,000 subscribers and get that AdSense money. So Lisa was drop served. Yes. That was another thing. I know a lot of you tuned into Jeremy's members only live stream. I did not. I'm not a member on Jeremy's channel. However, I heard bits and pieces that that she got served, but she got drop served. And a lot of people, I'm assuming, are like, well, Pat wasn't served because he, by
the bottom door.
Well, it was like, why wasn't he drop served? Because they couldn't find him. They knew where she was, and as soon as you open your mouth and say, yes, I'm here, you get served. Sorry, you get drop served. You actually grab the papers. But they could not find, the difference with that situation is they could not find Tat to serve him. So, and I do, before we get started with this, I do have to read the super chats from last night that I missed, because I want to make sure that I get everybody's super chats in, and I read them. And since we kind of cut off quickly last night to go to Tug, I did not read all the super chats, and I want to apologize.
While you do that, I got to go break my bedroom door in because Tiny decided to lock himself on the inside of it.
Oh, awesome. You have an interesting time with that. Like, we had a $5 super chat from Bad Duck. Said, what did the butt say to the toilet paper? Thanks for always sticking by my side. Of course, Bad Duck with the dad jokes. Can't have a Bad Duck on a stream without having a dad joke involved. And then a $1.99 super chat from the Zohan, spending her money. If you know, you know, no. If you know, you know, no. And then a $4.99 super chat from Marcus King. I appreciate all of that. And because I didn't get the opportunity and I was stupid enough to not read them last night, I read them today. Because I will always read your super chats. Even if I forget to do on stream, I will do it the next one. And thank you, Skipper, for the 99-cent super chat or super sticker on Georgie's stream.
Thank you, bestie.
And then thank you, Ong Hung Hero, for the $2 super chat on Georgie's stream. Dropping my like, but not my boxers.
I'd prefer the boxers, but thank you. Because, like, I can't take her nowhere.
Can't take this girl anywhere. She's going to get me demonetized now. All we know is Squid is going to buy us Legos. You better drop a bigger super chat than that if you want me to buy Legos, and because that wasn't a super chat at all. I can imagine that Randy would be happy about not having to mediate with I mean,
50 man scams. That's great.
That one. All right, so let's quick read this order from earlier today. The first one. So, upon consideration of the foregoing, it is ordered the 17th day of January. Defendants have filed a motion to excuse mandatory mediation. No response is necessary. Under the court's scheduling order, a party must request the court to excuse the mediation requirement upon a showing of good cause. Defendants have shown good cause to excuse the mediation requirement, at least for the time being. He leaves that caveat there for the time being. Therefore, defendant's motion to excuse mandatory mediation is granted to the extent that mediation requirement set for, the mediation requirement set for by the final scheduling order is suspended until further notice. So, until further notice. So, it's a win for now.
Right.
I'm not saying that mediation will come back in. I'm not making that prediction. I don't know the judge. I don't know. But there could be some actions where the judge is like, okay, that the mediation needs to happen. So he wrote his order in a very specific, and I like this judge because he writes his orders in a very particular way. For now. I'm not saying that just because mediation isn't appropriate now, that I don't think it won't be appropriate in a month. So for now.
Patience, Nikki, patience.
Yes, we're getting to that, Nikki. We're getting to that. We just had to read the motion from earlier today so that we're all on the same page about everything that's happened today. I just didn't feel the need to do a live stream about this earlier today because it takes me 2 minutes to read the 1-page motion, and I didn't think that was an appropriate live stream topic. However, today, will LP and JC ever attend federal court in person? Possibly, but possibly not. We have this. So, and do you see that the judge, when he writes his orders, puts Gainesville Division, the only person in this shit show of a situation who does not put Gainesville in his orders is Bubbles. Let's be honest here. Like, he is the only one who doesn't. Therefore, he makes his audience think that it's not in Gainesville. It's like, just because it's the Pensacola courthouse in the Gainesville division. Like, details matter. Details matter.
Tiny keeps muting my mic.
All right, so we are going to get into this one, and I have some opinions and some thoughts, and I want to hear what y'all have to think, especially you, Georgie, because, you know. Hey, Yoda.
Hi, darling.
All right. This matter is before the court on plaintiff's amended motion to leave to file amended complaint. Defendants have responded in opposition. No hearing is necessary. For the reasons below, the motion will be denied. Background. This TLDR, basically. This litigation began on March 4th, 2024, when plaintiff filed a complaint against 2 people, Lynette Preston and John Cook. In that 16-page complaint, plaintiff alleged that defendants Preston and Cook committed defamation, violated Florida's Civil RICO Act, and tortiously interfered with business relationships. Defendants moved to dismiss the RICO and tortious interference claims. Before the court ruled on that motion to dismiss, plaintiff moved for leave to file an amended complaint. And before the court could rule on that motion for leave, plaintiff filed an amended motion for leave to amend along with new proposed amended complaint. It is the amended motion that is currently before the court. Footnote 1. Footnote's important. In that motion, the plaintiff has sought leave to file a 62-page amended complaint that would add numerous new claims and join 6 new defendants. Defendants Preston and Cook have responded in opposition. They have argued that the motion should be denied on the grounds of undue prejudice, undue delay, and futility. Rule 15A of the Federal Rules of Civil Procedure governs pretrial amendments to the complaint. The 21-day deadline for amending the complaint without court approval has come and gone. See Federal Rules of Civil Procedure 15A 1, A, and B. Allowing amendment without court approval if filed no later than 21 days after service or filing of a responsive pleading or Rule 12B or E motion. Plaintiff therefore may amend his complaint only with opposing parties' written consent or the court's leave. Federal Rules of Civil Procedure 15A2. Let's read this amended complaint, this footnote. The filing the amended motion for leave to file an amended complaint mooted plaintiff's motion for leave to file an amended complaint. So document 47 mooted document 40. This judge likes the word moot.
Which is why you say it all the time now.
I found myself using it more and more and more, and I didn't understand why until I read his until I keep reading moot in his Oh my god, I'm starting to talk like the judge. Damn.
And his actions.
I mean, it makes sense though. It, you know. And hold on one. I have to open up my control room because we forget to do stuff, and then I can't see the chat as easily, and I can't participate in the chat as easily because in StreamYard I cannot tag people, but in the
Control room.
that word right there, control room, I can actually tag people. And why is my internet being super slow when it comes to loading things? There we go.
Thank you for teaching me how to do that, by the way.
Pop out chat.
Yeah. Now
It's so much easier to do it that way because then I can tag people. Whereas if I can't tag people if I'm just in StreamYard, it just doesn't let me. And that sometimes confuses the chat when they can't see me tag people.
Yes, Al.
Yes. What Judge is saying, document set 47 cancels out document 40. Yes, exactly. It's just this judge uses the word moot more than any other judge I've ever seen in my life. And I am currently in the process of looking up documents in my other cases that are going to appeal and seeing if I can find updated documents in any of them, including the Carly Gregg. And of all the judges I've ever seen in my life, this is the only time that I've ever seen the judge use moot more than once in a filing. It's moot. At least moot's easy to pronounce.
Right.
The word moot's just funny to me, and I don't know why. All right. Do you want to read this next part?
Yes. Because defendants have not consented, plaintiff requires the court's leave. A court should freely give leave when justice so requires. ID, but leave to amend is not an automatic right. Reese v. Herbert, 527 F 3D 1253, 1263, 11th Circuit, 2008, cleaned up. Instead, the decision whether to grant leave to amend a complaint is within the sole discretion. Daddy just walked in with food and he's like, yes! Wow. I lost my place. Instead, the decision whether to grant leave to amend a complaint is within the sole discretion of the district court. Lori v. Alabama
Court of Criminal Appeals. Okay. 256 F. Hey, that's around my hometown. If it's 256. 11th Circuit, 2001. See also Forbes v. Sears, Roebuck and Co. 30 F 3D 1402, 1405, 11th Circuit, 1994. District courts have broad discretion to grant or deny leave to amend. In the exercise of its discretion, a district court may deny leave to amend on the grounds of undue delay, bad faith, or dilatory motive on the part of the movement. What are you doing to me? Why is your fingers wet? No, sir. Those words are null and void in this house. Nope.
You gotta love being derailed by a tiny kid.
Oh, it happens all the time. She is right here. Her dad is home. He is out watching TV, and she would rather hang out in here.
He's shoving his food in my face. Listen to the excitement, though. You got a Smurf.
Huh?
He brought me his Happy Meal and then shoved his toy in my face.
He wants to play. How dare you deny a child there? I'm kidding.
There's your Smurf. He got a Smurf in his Happy Meal.
They still make the toys and Happy Meals?
Yeah, apparently.
Some of these writings from the judge are amazing. Yeah, Squid, save us. Okay, I will. You want me to read while you deal with this?
Yes, because I'm getting beat up.
Okay. On the grounds of undue delay, bad faith, or dilatory motive on part of the movement, undue prejudice to the opposing party by virtue of the amendment and futility of the amendment. Reese cleaned up. So the question before the court today is whether any of those grounds for denying leave to amend are implicated by plaintiff's proposed amended complaint. Now I have to go because I closed the dining room door and she's at the door going, help, help, help.
So
help.
where were you?
Her dad opened it up and she closed it back on him. Like he opened it up.
What?
All right. So the question before the court today is whether any of those grounds for denying leave to amend are implicated by plaintiff's proposed amended complaint. The answer is yes. And the grounds are undue prejudice and undue delay. Wow. I see the undue delay, but the prejudice, I'll have to read further on that one.
Of the potential grounds on which leave can be denied, perhaps the most important factor and the most frequent reason for denying leave to amend is that the opposing party will be prejudiced if the movement is permitted to alter his pleading. Danbrog?
Yeah, Danbrog, Redress, second district of Florida, 2001. I skip all of this because it saves time, because it's not really important to what I, in my readings anyway.
I usually go court, jibber jabber, and then can proceed to the words.
Yeah, plus it trying to say you don't have to read this. Yeah, I just read the name of the case and what district it came out of, generally speaking. That's just me though. Everybody's different.
If I can pronounce the words in the cases, I can read them. But if I can't pronounce the names or whatever, I'm just like, oh, this is just more court jibber jabber. And then I go back to the motion.
Yeah.
Let me out, she said. Let me in, let me out, let me out, let me in.
They're in the playroom playing. So yeah.
Court
you can skip to down here.
Explaining that the most important factor to consider in deciding whether to grant or deny leave to amend is prejudice to the opposing party. Courts typically find undue prejudice when the amendment unfairly affects the defendants in terms of preparing their defense to the amendment. Mentor v. Prime. In the proposed amended complaint, plaintiff seeks to add claims against 6 new individuals. One of those individuals is Bruce Maxton, the attorney of record in this case for defendants Preston and Cook, Doc 48 at 3. The proposed amended complaint seeks to bring claims to tortious interference with business relationships, civil conspiracy, and aiding and abetting against Mr. Maxton. Mr. Maxton is licensed in Massachusetts, and therefore he is subject to the Massachusetts rules of professional conduct. Oh. Although Mr. Maxton is not licensed in Florida, the local rules require him, as an attorney admitted to appear pro hac vice, to comply with the rules of professional conduct promulgated. Did I say that right?
Promulgated
by the Florida Bar, ND Florida Lock R11-1 G1. Those rules similarly prohibit an attorney from serving as both an advocate and a witness. Under Rule 3.7a, a Massachusetts attorney shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness.
Massachusetts Rules of Professional Conduct 3.7a, which I actually have, by the way. Comment 1 to Rule 3.7 states that combining the roles of advocate and witness can prejudice the tribunal and the opposing party and can also involve a conflict of interest between the lawyer and client. Totally understand that. And yes, if y'all haven't subscribed to Yoda, go ahead and do that. He is going to be live streaming a memorial service not the funeral. That was yesterday. A memorial service for Uncle Frank tomorrow night
By
at
the
7
VFW.
at the VFW. Like Baby Squid, Queen of the Channel. Yeah, this is her channel. I just run it.
Right?
I just do the talking. She does the actual like picking out cases and stuff like that. All of this to say that Mr. Matskin would be unable to continue representing defendants Preston and Cook if he were joined as co-defendant. I think that was half the point. Like,
Duh.
that is so, because I understand why the judge had to put it in here, but I understand if I have read enough of the documents and seen enough of the context of this lawsuit, that would be half the point of them putting Bruce on here, is that he can't represent them anymore. So, it is what it is.
That means we have more lawsuits in our future, because if you remember Jeremy saying, if this was denied, he would just start a whole new lawsuit.
Yeah, and that's part of my thoughts on this is like, okay, we're gonna have another lawsuit, which so temporarily it's a win. Emphasis on the temporary. And that's the thing that the discussion that we need to have after we finish reading this is, it's a temporary win, because just because you didn't get added to this lawsuit doesn't mean there won't be another one. And you made Jeremy mad at us with your what the hell's ecosystem, that he's going to do it. He doesn't strike me like, I don't know Jeremy personally, but he does not strike me as the person to say something and not go through on his word, whether that's positive, negative. He doesn't strike me as the type to say something without meaning it. And therein lies the issue. So
don't poke the bear.
All right. That is so because if Mr. Matskin were joined as co-defendant, that it is inevitable that he would be called as a witness at trial, the same trial where he would be representing defendants Preston and Cook. At such a trial, Mr. Matskin would be placed in the unattainable position of attempting to look out for his own personal interest while simultaneously attempting to look out for the interests of defendants Preston and Cook. See Putnam v. Head, 11th Circuit, 2001. Recognizing that the roles of an advocate and a witness are inconsistent. Additionally, there is a serious risk that the jury may be confused were Mr. Matskin to appear at the trial as an attorney, witness, and a party. See Florida Rules of Professional Conduct 4-3.7 comment, recognizing that the trier of fact may be confused or misled by a lawyer serving as both an advocate and a witness. Because such conflict and confusion is precisely what the rules of professional conduct seek to avoid, Mr. Matskin would be required to withdraw or be disqualified by the court, footnote 3, from representing defendants Cook and Preston were the proposed amended complaint accepted. See U.S. v. Guez, Southern District of Florida, October 7th, 2003. Disqualifying an attorney because an attorney may not act as both an advocate and a witness in the same proceeding. Accepting the proposed amended complaint, therefore, would deprive defendants Preston and Cook of their legal counsel midway through this litigation. I do see that being an issue. Like, to be honest, like, plain devil's advocate.
Yeah.
At the start of this case, defendants Preston and Cook were proceeding pro se until Mr. Matskin agreed to represent them, or Mr. Matskin pushed his way in there. They had no idea who Bruce Matskin was at the start of this trial, or at the start of this litigation.
I'm just glad it's not just my kids derailing it.
Nope. And it's the thing of like, everybody has their stream derailed by a child at one point or another. It happens to Megan and Tug all the time. It has happened to Mo in the Deep End. It happens to the best of us. And given the limited financial resources of defendants Preston and Cook, footnote 4, the court is concerned that they would be forced to return to pro se status if Mr. Matskin withdrew or was disqualified. So footnote 3, although in certain situations the court have permitted an attorney to serve as both an advocate and as a witness, there is no way the court would permit Matskin to represent defendant and Cook at trial within this case while simultaneously attempting to represent his own interests as a witness and named defendant. The risks are way too great and potential pitfalls way too numerous. And then footnote 4, the court has previously been informed that defendants Preston and Cook are of extremely limited means.
I can't.
And okay, and yesterday or the other day, I had mentioned to Coop, like you guys were talking about the context, and I look at it as like I'm trying not to know the context because I'm trying to be in the judge's seat or see what the judge sees. And this right here tells you that he does not know the context.
The whole footnote tells you he doesn't know the context
yes.
of the history or understanding of why they're wanting to add Bruce.
Yeah, but footnote 4 really shows that he doesn't really he understands, but he doesn't really understand. And that was my point, because if the judge doesn't fully understand, the jury won't either. So there's kind of my why I look at it the way I do. Is because I understand, and in every case I'm like that I know that there's a context with. There's every case I'm involved in and I see go to a jury trial, I always know that there's more information than what the jury is seeing. And we're always like, I wish the jury could see this. I wish the jury could see that. But at the end of the day, they can't. So you kind of got to go with what so that's why I know there's more context than what even I know, but I'm trying not to see it from
Andrea's comment.
Personally, I think keeping him as their lawyer is a benefit to I don't disagree with you. And this goes back to the whole trying to be non-biased, but at one point in time, at a certain point in time, even when you're trying to be non-biased and point out stuff on both sides, there's just way more BS on one side than there is on the other. So there's another see, and Max, I see another lawsuit being filed with those 6 defendants.
Jeremy already said there would be.
So to try to get Bubbles removed?
No, a whole new lawsuit.
Yeah, a whole new lawsuit. I don't see him trying to get Bubbles removed, because this is just like Jeremy has even said, Bubbles is the best lawyer that he'd never had to pay for.
Mm-hmm.
So I wouldn't personally want to get that person removed if they are helping my case. They are helping my case. They're making a case for me.
Gary said the haters think the depots are canceled now. Are they that retarded?
She's not being. That's the thing, though. She's not being deposed as a defendant. She's being deposed as a witness. There's a difference.
Exactly.
There is a difference. So if you were being deposed as a defendant and you were no longer a defendant, then of course you're not going to get deposed. But she's being deposed as a witness. There is a completely. Yeah, I mean, I'm sorry, but I have some haters commenting on my comment, on my videos, and they're saying things. And I'm like, tell me you don't know how the court system works without telling me. That's not how any of this works. And then they take every so in every lawsuit, no matter who's right and who's wrong at the end of the day, there are things the plaintiff is going to win, and there are things the defendants are going to win. That's just how it works. Just because you win a legal argument in the midst of filing motions does not mean you will win the whole case. And I think that's they're ooh, this is a win for Bubbles. Technically speaking, but the judge is making really good points. But at the end of the day, Randy has to ask, because if Randy doesn't ask, then is he really doing due diligence with his client? So, and really doing what his client wants if he doesn't even ask. So, and adding defendants to this case would be cheaper than filing a brand new lawsuit and doing all of this process all over again. So I understand that even if it wasn't going to be, even if Randy knew that it wasn't going to be approved, like, he has to do it. There are just certain things you have to do. Like in a criminal trial, when the state rests his case, you always see the defendant move to have the charges dismissed, that the state didn't prove their case. Even if they did, you have to do it just as a due diligence for your client that you did everything you could to get their charges dropped. So, like,
Yeah.
you know that certain things are going to happen, even though you think they're stupid. So even if Randy knew all along that they were never going to get added, he has to try to do the best he can for his client, both case-wise and financially. And yeah, and that's where I think Bubbles is another problem, because that person commented that he wins this, like, it shows that Jeremy is a vexatious litigant with all the motions that Bubbles is filing. I'm like, every motion that Bubbles files costs Lynette money. So when you file motions that you know are frivolous, you're costing your client money. This one wasn't frivolous. Like, maybe Randy knew it was going to get denied, but this one has to be filed because in the long run, it will save your client money if they get added.
Yeah, and it gets the information about the ecosystem in the system.
Yeah, and there's like nuance to it, that like there are reason things happen procedurally that we know don't make sense, but like they have to be done to say that they're done. Yeah, it's you nailed it. The main duty of a lawyer is to get their client's charges dropped. Yeah, and I understand some of the motions that Bubbles is filing. I just don't agree with what he's saying in the motions. There's that too. Like, some of these motions that he's filing, I understand why he's filing. I just think the arguments he's using are stupid. And there is a huge difference between filing a... Sorry, she has her pad right here, and she's not even here.
Gary said that one of the chatters from their side, Florida native, reported Coop and I streamed today for defamatory commentary.
Oh, seriously? For what?
I don't know what I did that was defamatory, because everything me and Coop were speaking of was stuff that had happened. So
yeah. And it's like the main and going on with this one in a civil trial is to do the best due diligence for your client while costing them the least amount of money. So Randy, even if, and I don't know, I don't talk to Randy, this is my opinion, this is not what he's thinking. Because I know the haters are going to go like, well, how do you talk? That's not what he thinks. If I were Randy, even if I knew that these were going to get denied, I know that I have to do everything I can and try. And what's the worst thing the judge can tell me? No. So in the essence of saving my client time, energy, money, and stress in the long run, I'm going to try to just add it here versus going through this process from the beginning, which is going to cost more money, more time, more stress. Do I think Jeremy's going to do it because he can and he wants to? Absolutely. However, even before Randy filed these motions, he knew that they were going to possibly get denied. This is the best way to go about it, in my opinion. Not a lawyer, just my court watching, trial watching, document reading, nutty self. Yeah. That's just my opinion. Oh my goodness. Hey, Robert. Oh no. Did I miss something right here? What did I miss?
Robert Towers passed away last night.
Oh my goodness, that's the worst. That's the worst. Mediation doesn't. Yeah, I can't. Mediation doesn't mean much. They're not going to be settling, and they're not going to be going to court. So there's really not much need for mediation. Yeah, it would be a waste of time and a waste of money.
Hey,
it also
Kiko.
shows Deborah, right there. It also is a foundation for future lawsuits.
That part.
I'm not a lawyer. I just slept at a Holiday Inn last. Like, all right. Let's get back into this. Certainly, losing counsel and having to defend themselves pro se against the allegations in this case would unfairly affect the defendants in terms of preparing the defense. Minter 451. It would also further complicate the case because litigation involving pro se litigants is notoriously more problematic than litigation with counseled litigants. That's a very true statement.
I mean, even having Bruce as an attorney makes it even more problematic because he supports their craziness.
Yeah. Right here, I agree with you, Southern Red Sox girl. I give credit to the judge, even though he's being fair to all parties. Yeah, and he's calling it like he sees it, and he's not prejudiced. And that's another thing that, like, whatever the decision happens in this, it's kind of appeal proof, because the judge is doing this too. The judge is making himself appeal proof, which is important process of a judge, because you don't want to. Everybody appeals because it's their next step on how to defend themselves. However, the appeals only are on the basis of judicial misconduct.
My dear.
So, oh my God. That's so funny.
I can't deal with those.
I'm pretty sure Megan is in love with her husband, considering they've been married a while. I can't say how long because that would mean I know a little bit too much about Megan, and I also don't want to call her old.
They keep playing with Megan and Tug, they're gonna get something they didn't plan for.
Yeah. Lynn, thanks for being a member for 1 month. First kid is a hurricane, second kid is a tornado, voice of X.
It's true though. It's very true. And as you keep going, the third one gets worse, and the fourth one's worse.
I only have one, and I am too old to have another. Elu, member for 1 month, late to the party. You know, adulting and all. Oh, that adult stuff. The Mr. Squid didn't work overtime today, so it was kind of our Saturday turned into a Friday. So, you know, it's all about that. Yeah, there's this too.
Yeah, that part.
This
whole
part. And I've seen Megan has showed some of her sister's cases that she's litigated on stream. Not the actual like information of the whole case, but like watching her sister on a stream. Right? Any public information or any appeals court that's streamed. Megan has seen her sister litigate an appeal. And Megan's sister is you think Megan is no nonsense. Plus, let's put it this way. Megan's not a lawyer, but her sister is. Some of her other family members are. Some of her friends are. Like, you don't think covering court cases for this long of period of time that you don't make friends with lawyers? Like, and if they can't help you, they can refer you to someone who can. Like, you know what I mean?
Wow.
Santa White think they're worried because it was denied, laughing and betting if Megan will beg tonight, even though she's away at the funeral. They're so ugly. Yeah, I just can't, like, yeah, and because Megan's not really one you want to mess with. And yeah, I know she's been married over 20 years. It's like, I didn't want to say, hey, Megan, you're old. You've been married over 20 years, you know, like,
I mean, I'm not far behind her.
Let's just put it this way. One of her daughters is an adult. So she's been married a while.
Right?
Huh? What was that?
Our daughter's 21, right?
18.
Yeah.
Like, all right.
I mean, I'm still young, but me and Mr. Wilburn's about to celebrate our 15th wedding anniversary, so.
I can't celebrate a wedding anniversary. I am married. However, we've known each other for 20 years.
See?
19 or 20. He will be able to tell you I wouldn't. Because my memory sucks. So, hey Rick. Like, and there is a certain time, and with this too, like there is just a certain time to to just stop talking about things, you know? Like, you know what I mean? Like, that would be when you're threatened with a lawsuit and they attempted to add you to one lawsuit, you would think that would be the time that you would want to stop talking. F off, I've been married for 39 years.
So, you know how people talk about moving fast? It's not good to move fast. Me and him started dating on my 18th birthday and got married 3 months later.
Oh, well, you know. We met on an aircraft carrier, and the rest is, well, you know, two stupid kids. All right. And even if defendants Preston and Cook were able to find replacement counsel, there would be a significant delay in this litigation because they would first need to find time and to find and retain new counsel. New counsel would then need time to get up to speed. Speaking of delay, I like the way this judge writes.
I love him.
He writes like I would, or like I talk. Like, speaking of, granting plaintiff leave to file the proposed amended complaint would unduly delay the resolution of this case. Prejudice the non. Why are you saying help me? You're holding a flashlight. That's you. Can you hear her? Help me. Help me. See? She's got flashlight.
I can see the light too. She's shining it everywhere.
Oh yeah.
She's putting a spotlight on Mama.
Mama doesn't need it. No, that's what I don't. That's what I have. That's what I have a problem with you. You shine it at yourself. Cell block 65, also known as the Enterprise or Enter Prison. So, granting plaintiff leave to file the proposed amended complaint would unduly delay the resolution of this case. Prejudice to the non-moving party is not the only factor the courts consider when determining whether to allow leave to amend. In Engel cases, 11th Circuit 2014, undue delay may also be clearly support denying leave to amend. Here, plaintiff's 16-page complaint is a relatively straightforward one that names 2 defendants and brings 6 counts, 3 per defendant. Plaintiff's 62-page proposed amended complaint, on the other hand, is convoluted and seeks to add 6 new defendants and many more counts. That is very true. Like, it goes from a nice, clean-cut 16-page, they did this, times 2.
Oh, wait.
To a convoluted 62 pages, difficult to read. Like, yeah. No. Granting plaintiff leave to file an amended complaint would greatly and unnecessarily expand the scope and complexity of this lawsuit. The proposed expansion would cause substantial delays in the disposition of a case that is nearly a year old. See Lover v. DC, District Court, or DC District Court, 2008. Allowing a plaintiff to amend his complaint may unduly prejudice a defendant if amendment would delay the litigation or expand the allegations beyond the scope of the initial complaint. See also Dannebrog Rhetoric, explaining that an amendment may unduly prejudice where the defendant would be put to added expense and the burden of a more complicated and lengthy trial. I don't disagree. He's got a really good point. There are several ways in which granting plaintiff leave to file the proposed amended complaint would unduly delay this lawsuit. First, the 6 new defendants would need to be served with the amended complaint. Potential service issues could arise, as they often do, which would delay the case's progression. Even if plaintiff perfected service without issue, each new defendant would have at least 3 weeks, assuming no extensions, from their respective dates of service to respond. See Federal Rules of Civil Procedure 12A 1AI. For any new defendant who waived service under Rule 4D, the response deadline would be 2 months from the date of the waiver was sent. Second, each of the new 6 defendants would likely engage in motions practice. Plaintiff would have 2 weeks to respond to each respective motion and 3 weeks to respond to any summary judgment motions. See the Northern District of Florida, Local Rules 7.1E, 56.1C. The court would then need time to consider and resolve each motion. Therefore, it is likely that additional motions practiced from the 6 new defendants would substantially delay the final disposition of this case. Lastly, joining 6 new defendants and adding a multitude of new claims would negatively impact the discovery process, a process that has already been ongoing for several months, with a whole bunch of issues in itself, might I add. Like, that's not the judge, that's me. Like, that has... See, if I would have written this, I would have been like, the discovery process, the process has already been going on for several months with several, like, issues in its own. It's just funny to me. The 6 new defendants would need to conduct their own discovery, and plaintiff would also likely seek to obtain discovery from each of the 6 new defendants. It is also possible, indeed likely given the history of this case, that discovery issues would lead to filing motions to compel. I mean, okay, he said it a couple sentences later. like that's yeah. Bubbles has several bar complaints filed against him. He has to deal with that. Oh, he's got another couple coming. He's got he's got another couple coming.
I had a lady in my chat this morning that said she filed one against him.
Her name didn't happen to be Mrs. Yoda, did it?
Besides her, there was another woman in there that said something about
interesting.
She had run into Lynette and Chieflin. No. I saw Miss Yoda's comment, but this lady said she had run into Lynette and Chieflin, and then she had issues with Bubbles, and she filed a bar complaint against him.
This one right here just means Jeremy would need to file a new federal charge for all of them to cover the RICO actions of the anti-Hales social media ecosystem. And Jeremy already said, I believe in last Sundays or the Sundays before live stream, that even if it got denied, he still had plans in the works. I don't know what those plans are. I am not privy to them, but I can assume it's a safe assumption that they're going to be sued regardless of whether they were added to this one or whether it was a new filing altogether. Edie. I like Edie.
Hey, my adventures.
My adventures in homebrewing. How are you? All right.
Yes, Lisa got served today.
Yep. Drop served.
They tried to hand it to her, and she's like, I'm not taking that.
Yeah, that's when you get drop served, because they made contact with you. Mm-hmm. Like, it's a little bit different when it's when it's DJ Radis that they can't find. You can't serve someone if you can't find them. But if you've made physical contact with them and you are within an arm's reach of them and they still refuse to take it, then you can drop serve because,
What do y'all want?
Because they can. Please hit the like button on both Squids and Georgie's stream if you would be so kind. Yes, please be so kind.
I have all 3 cats at my feet.
Drop it like it's hot. Hey, Musey, hope you're doing okay. LP is getting here money from all the people grifting to her. She's not losing any of her. Yeah, it's pretty. I don't know. Like, and I know people super chat Jeremy too, and like it's, so there's that. But like, Jeremy got super chatted long before this. You don't make it to 700,000 subscribers on your own with without people super chatting you. You know what I mean? Like, it's a little different than people sending money to Lynette specifically for this purpose. Because I know there's a history in Northport and all of that, but like, she doesn't have a YouTube channel that's monetized. So it's not like people are, sending her money to support her channel. So yeah. Process, I'll use body cams these days to prove service. It's dumb to try and refuse service.
Right.
And I will have to take your word on that. I mean, I understand why they do, if they do, but I'll take your word for it. All right. The court would then need time to rule on each motion, which adds further delay to the progression of this case. It's also likely that discovery has already been completed and would need to be redone. For example, plaintiff has already been deposed by defendants Preston and Cook, but the 6 new defendants would likely seek to depose plaintiff again for their own discovery purposes. It is inevitable that permitting the amended complaint would substantially lengthen the discovery period, require a modification of the dispositive motions deadline, necessitate a new trial, and ultimately delay the resolution of this matter. See Lover at 248 FRD at 324, stating that the joinder of new parties would undoubtedly necessitate further extensions of the discovery deadline and would delay the ultimate resolution of this litigation. At the end of the day, the court is convinced that granting plaintiff leave to file the proposed amended complaint would unduly prejudice defendants Preston and Cook. Sorry, Judge Bolitho, but if you wrote this or whoever wrote this with you for you needs to proofread, because that one wouldn't be picked up by a what am I talking about? Wouldn't be picked up by an automatic, it wouldn't be seen
Correction.
as a misspelling, because Cook, that is another way of spelling Cook, just not his way. So see, I call things out where I see them. I'm like, dude, you need to proofread. Like, not just use spell check, proofread. The court is also convinced that granting leave would significantly expand, complicate, and delay the ultimate resolution of this case. See Charles Allen Wright et al. Federal Practice and Procedure, 1487, Civil 3rd Edition, 2010, stating that if the court determines that the proposed amendment would result in defendant being put to the added expense and the burden of a more complicated and lengthy trial, leave to amend may be denied. Because the interests of justice would not be served by granting plaintiff leave to file the proposed amended complaint, the court will exercise its discretion and deny plaintiff's motion. For the reasons above, it is ordered that 1. Plaintiff's motion for leave to file amended complaint is denied as moot. Plaintiff's amended motion for leave to file an amended complaint is denied. This case will proceed on the original complaint, document 1, footnote 5. It is so ordered. 17th day of January, 2025. Zachary C. Bolitho, United States Magistrate Judge.
McDreamy.
Yeah, Magistrate Judge McDreamy.
There's a pending.
Oh, you got it. You got it. I'm so used to doing this for myself.
I know. There's a pending motion to dismiss filed by defendants regarding counts 3, 4, 5, and 6 of the complaint, docket 17. There's also a pending motion for summary judgment filed by defendants regarding counts 1 and 2 of the complaint, doc 20. For planning purposes, the parties are advised that the court is drafting a separate order that will grant the motion to dismiss with respect to counts 3 and 4, the RICO counts, but will deny it with respect to counts 5 and 6, the tortious interference with business relationship counts. The parties are further advised that the court is drafting a separate order that will deny the motion for summary judgment.
This is why you always
just
read
got denied in a footnote again.
This is why you always read the footnotes.
Always read the footnotes. Thus, the case against defendants Preston and Cook will be moving forward on the complaint's defamation claims, counts 1 and 2, and the tortious interference claims, counts 5 and 6. Brucey got a quarter of a win and then got denied.
I don't know if he is. I'm not sure. I haven't seen anything come up on my, like upcoming streams. But here's the thing. Okay. Take this with a grain of salt. But you know how people have been certain people have been cherry picking what they read, and what parts of documents that they read to make themselves look better. How much you want to bet that this did not get read on any stream that they ever do?
On that side?
Yes. This right here will never, ever, 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 ever be read. I will put money on it unless they hear me say I'll put money on it and then they read it just to spite me, which is quite possibly true. But without interference of them hearing my stream, they will never know that this footnote exists. So just for, hey, I have my favorite. Brucey got kicked with the denied and the footnote.
Yes, he did. He's like, I'm going to hand you this little win, and these other people aren't going to be added to the case, but you're denied on your other motions.
Right. Tug said he usually doesn't stream on Fridays. Well, here's the thing. Megan always said in the past that Megan never used to stream on Fridays because Fridays was family night. However, lately they've been taking their norms and what they normally do and throwing those out the window. Like, usually Megan streams at like 11 o'clock in the morning or 10:30 and does like a 10:30 to 2:30 kind of stream. And now she's been streaming at night with Tug. So it's like, like what people used to do before this case, they don't really do anymore. Yeah, I know. His Vice's funeral is tomorrow. I want to say morning, 8:30, whatever time zone that Logan, Utah is in. So
that would be on Mike's time zone, I believe.
I want to say it's Pacific time, but I don't know enough about the Pacific and Mountain time zone to know when one starts and one ends, because I have a hard enough time keeping track of Eastern and Central.
Right? That's all I've known my whole life, and now having friends on the West Coast, I'm having to keep up with. Mike's 2 hours behind me.
It is in Mountain. Okay. Yeah, and I'm sorry, Utah is Mountain. That's what I thought, but like Nevada is technically, there's parts of Nevada that are technically Pacific time, like Vegas is Pacific time. So it's and there's the other thing with time zones is there are areas of the country who do daylight savings time, and there are areas of the country who do not. So I also have a hard time, like, yeah. So we read it out. I did. We can read it again.
Oh, you want me to read the footnote again? I can do it again.
Yeah,
there's a pending motion to dismiss filed by defendants regarding counts 3, 4, 5, and 6 of the complaint, docket 17. There's also a pending motion for summary judgment filed by defendants regarding counts 1 and 2 of the complaint, docket 20. For planning purposes, the parties are advised that the court is drafting a separate order that will grant the motion to dismiss with respect to counts 3 and 4, the RICO counts, but will deny it with respect to counts 5 and 6, the tortious interference with business relationship counts. The parties are further advised that the court is drafting a separate order that will deny the motion for summary judgment. Thus, the case against defendants Preston and Cook will be moving forward on the complaints, defamation claims, counts 1 and 2, and the tortious interference claims 5 and 6.
I just have to
So two denials in the footnote?
Yeah, I just have to address this one comment. Where did I see it?
Oh, the CNN one?
No, it's in Logan, Utah, his hometown. But there was another, this one. The whole internet needs to deny Jeremy Hale as a grifter and a narcissist. Can you provide your receipts that he is a grifter? He runs a YouTube channel, and does that for money. So in a way, we all grifters, because we do this for money. Like we do this to make a living. So in a way, you can consider all of us grifters. But thank you for the view time and the ad revenue. I appreciate it. It helps pay my bills. Thank you.
If Mikey is still watching, which I'm pretty sure he is, those screenshots you just sent me is absolutely hilarious. Did you watch his video that he posted this morning?
Whose
Mike's
video? Mike's. I started to, but like I think I got like 3 minutes in. So before I got sidetracked. So, you know.
Expert Slide. I can.
Yep. So it's just one of those like yeah. Like oh my goodness. There we go.
We'll ship y'all to Expert when we're done.
Thank you. Thank T Underwood. You are I love you. Yes. Jeremy is a fighter, not a grifter. And see, and you can consider everybody who runs a YouTube channel and asks for super chats a grifter. Because at the end of the day, people do this for money. Yes, it is fun. Don't get me wrong. But it's a lot of work. And some people do it for a living. I'm a stay-at-home mom. This is my source of income. So like,
Same.
Send them super chats if you want to. If you call me a grifter for that, I'll getting my grift done. But like, hey Gail, I'm new to your channel. Glad I finally got here. Good to see you. Tug is going live tonight. I am going to look up and see.
The only one that come up for me was Expert.
Well, that's because Tug's probably not live, and it's not a.
I don't think he has anything scheduled either. I can go back and look.
I will be doing a live stream tomorrow at about 10-ish Eastern time. It's a business, not grifting. And if people want to consider doing YouTube a grift as a whole, because we actually enjoy working, like this is fun. And remember, it's a lot of work. We're hustlers. And it's one of those things of like, remember that just because what you see here, honestly, to put yourself in front of a camera for that much, you have to be somewhat of a narcissist, not necessarily a bad thing. And I'm convinced that if you interviewed every person on the planet, they have at least 1 to 2 narcissistic traits. Not narcissistic personality disorder, but traits that are narcissistic. Oh, and Doug, I don't remember if I finished my thought, but when you made a comment about the footnotes, I always read the footnotes because the footnotes are where the juice is at. And if you want some tea, you read the footnotes. Read the footnotes. Tea is always in the footnotes. That was one of the problems I had with another law tuber who Megan and him notoriously got in a disagreement about Maya's the Kowalski case, because Megan said a comment, and I remember this specifically. Megan made a comment on Ricada's stream, and he says, I don't read the footnotes. It's like, you always got to read the footnotes because the footnotes are there for a reason.
Yeah.
The footnotes would not be there for a reason. The footnotes would not be there if there was not a purpose. And a lot of times, that's where you get the judge's snark.
Especially if the footnote is created by a judge.
Yeah. A lot of the times, that's where you get the snark, is in the footnotes. Like, those are the best places to find it.
And McDreamy has always got the snark in the footnotes.
I really, even though sometimes I have a hard time reading it, it's because I have a hard time reading. Let's put it that way. But like, yeah, that's like driving a car and paying no attention to the gas gauge. Or, nice. This is awesome. My granddaughter is studying for her bar exams. I wish her the best of luck. Musi, I can stick your link in. Can anybody drop Musi's link? I don't have it in front of me. I have to open up my rogue. Megan. I have my I have a big section of stuff, and there we go. I have like a spreadsheet of everybody's links to their channels that are usually on my channel, and sometimes I have to scroll through because I don't have it organized as well as I need to. But I did it, and I just want to thank Rick Friend for the $2 super chat. Denied. Hashtag denied. Let me read that accurately. And I actually did manage to read all the footnotes, or not all the footnotes, all the super chats today. I didn't screw it up like I did yesterday. He was gently blowing up bubbles until the footnote, then bubbles burst.
Yep.
I'm sorry. This is gonna make I have to screenshot that because that is the that comment right there is going to make my 2025 highlight reel for the best the best comments of the year.
Right.
Because that is so perfectly said and hilarious. Yeah. All right. Yeah. Okay. I'll skip what the Hales didn't ask for super chat and such. His main income is from the storage units, and that's true too. So but you know, everybody, just because you ask for a super chat, if that's a grift, like, then call us all grifters. Like, you know what I mean? Tug is scheduled for a live, but we are going to go over the to the expert because he is reading what we just read.
Yes. And y'all know, expert squirrel.
Yep. Let Squid know that Tug is on a date. And truth be told, when you're on my stream, not like I'm any better without you, but like when you're here, I have somebody to actually speak to and squirrel with.
Not just we do every time.
We do every time. We do every time. Someone wants to warn people about Jeremy and his new business adventures.
Oh, look, a hater.
No, I don't. She's not a hater.
Oh,
I just.
Oh, wants to warn people about. Okay, my bad. I misread that. I apologize.
She's not a hater. I think she's pointing out somebody made a hater comment.
I apologize, Alicia.
So I unstarred all the. Yeah, exactly. Right here. It's offered in the YouTube platform. Why would someone say no to super chats? And honestly, I don't want to sound like this is going to come out really bad, but like, if people are willing to send people super chats because they like their content, why not me? You know what I mean? Like, you have people like super chatting all the time. And like, if people are going to do that regardless of if you are streaming or not, why not? Why not why can't it be you? You know what I mean?
Right. If the large channels can do it, why can't we do it? Why do we have to feel bad for doing it?
And it's like, at first I felt like really bad, like asking for hit the like. It's uncomfortable, and it's for the first like 3 months, it was really uncomfortable reading super chats because I'm like, people are paying to hear what I have to say. That's just weird to me. But then I'm like, if I wasn't streaming, that person would just super chat the next person that they watched because they enjoy the content. Like, you know what I mean? It's if someone's like Taz. Thank you for the $2 super chat. Hugs to my girls. If Taz didn't send that $2 to me, she would have sent it to somebody else.
Yeah. So
like, because that's just the kind of person she is. She sends super, and I'm not saying that people who don't, you know. And on Georgie's side, Suzanne 7IB Callie, Georgie and Squid, #1 YouTube ladies, and that was yours, Georgie.
Thank you, Mama Suzanne. I love her.
She is so fun.
I don't expect the supers. I don't expect it at all, but they mean a lot when I do get them.
The only person who I expect supers now is Hung Hero, because he usually super chats me at least once a week to say a word, to say someone's name that always comes out wrong. So I expect at least one super chat from Hung Hero per week, just so I have to say that name that is in a different lawsuit.
Cock.
Yeah. And Paul Voss, you didn't ask, but I wanted to. Thank you for the $9.99 super chat on Georgie's side.
Thank you, Pops.
Georgie's getting all the super chat money today. And Georgie, you and I'll have to set up a stream where we kind of do what Tug and Megan do. Is we'll set up a thing where one day we'll do it on yours and one day we'll do it on mine, and we'll have a
I'm
theme.
down.
So
I'm down. I enjoy hanging out with you. I don't
Forensic.
normally get along with females.
I don't either. So, but that's because we've had our disagreements. And when we've had our disagreements, there are disagreements. We understand why we disagree with each other. And then we move to hell on.
Yeah.
Oh, yes. Oh, and this right here. Al, I saw a comment earlier. I think it was from you. CNN got nailed for defaming a Navy veteran today. Yes. So on my Wednesday, on my Wednesday streams, I do a trial rewind. So before I get to Roy's super chat, this one, then I am currently working on an unaliving case from Vermont, but I will probably be done with it next Wednesday. Every Wednesday night from about 8:30 to 11, we are doing a night court. I speed up the trial to 1.25 speed so we don't have to listen to it at regular. We skip the breaks, we skip the bullshit. We don't have to wait for the jury to come in and out, all that stuff. So we kind of get through the meat of the trial quicker. But the next trial I am going to be doing is the CNN or the Navy vet versus CNN trial, because everybody knows that, one, I hate mainstream media, and two, I'm a Navy vet. So it's kind of like a perfect trial for me. So it's 8 days. I didn't. I
$5 million
into the video, but I was on a conference call with Vet Nation about that issue like a month ago. So I kind of have an understanding of what the video is about. I just don't know details. Because we were all going through paperwork together and like trying to vet paperwork on a conference call. So, and anyway, we might get snow around here next week. So if I stream a little more, it's because we're all homebound.
Right.
So, Roy, thanks for the $1.99 super chat. Hath, it's Hath. Hathcock. His name is Hugh Hathcock, and he's the owner of Velocity Automotive in Florida. I am also, for those of you who don't know, I am covering a federal lawsuit involving a quarterback who used to play for Georgia, but he entered the transfer portal yet again. So who knows where he'll be. But he is suing the coach of the University of Florida's football team, a former NIL staffer, and an NIL collective for $13.85 million deal that went bust. So I like those NIL issues. And I like where sports ball meets the law because I love sports. So I'm also covering that. But tomorrow I'm going to be going live at about 10:30 a.m. and just giving small updates on all the cases I'm covering because there's not enough information about any particular case to make a whole live stream by itself. So we have an updated court hearing from the Sean Stein's case, which is the Kentucky sheriff who unalived a judge on camera in his chambers. So there's that. There's an update from that. I have some updated docs from other cases, but nothing that's substantial enough to hold its own weight as a live stream. So I'm going to do mini, like a all-encompassing weekly update. So we will see how that goes. And Harry, thank you for the $5 super chat. Repeat that name again. Didn't hear it. And I said I would say it for super chat.
Super.
Even when I'm reading the documents, I just say Hugh, or I say that guy, or I say the owner of Velocity Automotive. I never say his name anymore because chat lights me up all the time. It's Hugh Hathcock because we are all 12 years old at heart.
So what is a half a cock? Does that mean it's not like fully erect? I mean, what does it mean to you? No, seriously. I mean, you said it. I'm
putting his name in the chat. This is his name. See, we're all like 12 years old at heart.
So he has an innie?
Super short.
have
Yes.
conducted?
So chat from day one of me talking about this case, even when there was only 5 people listening to me read this case, all 5 people were communicating in chat and making fun of how I said it. So I said that I'm no longer, because y'all are making fun of me, I'm no longer going to say it unless somebody super chats me. So now I literally get a $2 super chat from Ung Hung Hero every time.
Or Roy, or
Roy.
oh, there's another one who does it.
Yeah, Harry does it too.
Yeah, Harry. There's another one. They torment you. All the guys in the chat torment you.
Yes.
And I just join in on it.
If this trial is streamed, I will be. I do have a playlist where we've watched the body cam footage, or at least what was snippets of the body cam footage that Law and Crime released. You remember that? The and watching Squid turn red.
Roy.
Yeah. Laura Owens.
You swallowed cock. That's what I'm busting out laughing about.
Oh my god! But
Mother Wolf. No one forces.
I will be covering all of I will be covering that case too, and I do have all the documents that I've been able to find and some news reports in my Discord. I have 2 separate sections in Discord. I have a discussion section and I have a document section. So basically, if you want documents from a case, you can put I have the documents in an area that are easily findable. So they're not convoluted by a bunch of people talking about it. But if you do want document drops on cases that I am not following, this is As the Gavel Drops Discord server. Join As the Gavel Drops because they have document drops from, I want to say, about 100 cases every week. So
JW.
Yeah, I know. Oh, every time I go to click on it, it moves. Better than quarter. Yeah.
Quarter cock.
Hales BBB is a moot point.
Yeah.
Watching Squiddy turn red is always
it's so much fun to make her blush.
Y'all are funny. Remember to hit subscribe, leave a share, and like button, and press the bell for notifications. You won't always get them. I do try to post my live streams on my Discord and my Twitter, because I know that YouTube does not send out notifications very well, especially with these last minute live streams where it's like, I know something is coming, so I know I'm probably going to stream in the afternoon, but y'all don't know when I'm going live. So, speaking of documents, how is the Nebraska one going? Honestly, it's been on the back burner. I still have to call the clerk of courts with what we have going on in life, combined with all of this. It's just been like a paperwork nightmare. And the less people I had to call for paperwork, the better. So that one kind of went on the back burner. But I do owe, and the case he's talking about is documents in the case of William Serrano, which is if you watch Captain Kern and you know my friend Captain Kern, William Serrano is the man that's currently in prison for unaliving his daughter. So we are on the hunt for more documents, but Nebraska is another one of those states that only half puts them online. You never get the full story, and Sir Frank has been helping me get information on who to contact and how to get documents from that case. So it's yeah, and I that one I'm helping him out. Yes, it's helping me out because I'm curious, but at the end of the day, that man was not given the time in prison that he needed for unaliving someone's daughter. So that one's a little personal because Captain Kern is my friend. And yeah, right here. Oh, Mr. Squid was Navy too. I'm not the only one.
So, how many super chats have you gotten over there so far?
For me?
Yeah, you.
Oh, I think it counts everybody. It counts both sides.
With you having your studio open,
Oh, $15.97.
if y'all get her to $25 in super chat, she'll eat some more spicy balls.
They're not. They're
Garlics are
cloves.
brown. They're spicy balls.
They're garlic cloves. Yes, and that is my grift because that is like I will not eat. These are really good, but they're described as painfully delicious. Yeah, they are from the Pepper Palace, and they have cayenne pepper, habanero pepper, ghost peppers, chocolate dula peppers, reaper peppers, and oleo resin capsicum or capsicum. So they are heal. That's why they
Hopefully
stay
not
in.
Bubbles spicy balls.
There's a difference between spicy and salty.
Phrasing. Hi, John.
I love you guys. All right, I have to get going. We are going to redirect you to
expert.
Yes, the expert. I'm sorry, I just got a message from Musi, and I heard the Mr. Go see Mama. Go see Mama. So I have to get off of here. Bubbles, no balls.
Bubbles, no balls.
All bubbles, no balls.
All bubbles, no balls. No, Bubbles is all nose,
Oh,
no
no.
balls. Oh, there's your spicy balls. Thank you, Paul.
All right, guys. You can see all this spice.
Dig to the
I don't
bottom.
have
Get
water.
one
I
of
have
the
nothing
hot
to drink
ones.
around me right now.
How? Damn cat. Let go.
Oh my god. Oh.
I agree, Mother Wolf. Thank you for your comment.
Oh.
Bye, Cynthia.
This right here. I agree with you. It's just one of the things that the haters say, you know? Oh.
Not just the haters.
Well, yeah. Whew.
After that conversation you and I had this morning.
All right. I'm
like
going
that.
to get going because I need water now or something to drink now.
I said milk.
Bye, guys. It was fun being here. I'm glad y'all had fun. I had fun. Sorry, Squid. You're not sorry.
I'm being attacked by a cat.
Oleo capsicum or capsicum is pepper spray. Thank you, Jessica. Yep, and it is right here. It's hard to see, but you can see it. It's that right there. So yeah, I'm eating pepper spray. That's a someone needs a Mountain Dew.
Eyeballs.
Yeah, I did rub my eyes one time. It was a really bad idea. I don't recommend it. Later, guys, I go tell the expert that I said hello.
Let's go derail the expert, guys.
Yep, let's go derail the expert. Bye, guys. Have a great night.